Our Attorney General, Derek Schmidt.
Susan, thank you very much. Very kind introduction. It's great to be back at the Pachyderm. It's been a while since I've been here. I didn't go back and check, but I'm sure I've not been here during this term, which only started in January, but nonetheless, it's been a while, and it's good to be back. I'm glad this worked out, and thank you, John, for the invitation. I will say we have a lot of legislators here, and I've got a bone to pick with all of you. Because you've left me alone in Topeka. I'm now manning the front lines with Scott Schwab and our other two Republican statewides with the Democrat governor. So we're going to try to hold the fort until you all get back, but please hurry. And it'll all be good. I got to be very careful what I say today because I've got legislators here and they control my budget, and I got judges here and they control my cases, and they might be recording this and my wife might see it, and then I'm in big trouble. So I got to be very cautious. I thought maybe what I might do today is just talk a little bit about some of the current happenings at the AG's office. Some have been in the news, some maybe not so much. I think you've heard me say before, a lot of what we do, if we do it right and do it well, nobody ever notices, and that's okay. We're not out to make headlines, we're out to make good, and occasionally that's newsworthy. And a lot of it is just routine, solid, important, but day to day. I was just talking with Judge Kirby, we've got a few of those things that we do brag about sometimes, but this is not the day I'm going to do that. Instead, there's been an awfully lot happening lately, and some of it has been of consequential profile, so I thought I'd talk a little bit about that. So my game plan today, I thought I'd talk a little bit about some of our recent Kansas Supreme Court litigation. There's been a lot of interest come out of our court recently. I'd talk a little bit about some of our pending U.S. Supreme Court litigation. We actually have 3 cases pending at the High Court currently, which I know 3 doesn't sound like a big number, but 3's a lot to have up at once. Particularly from a smaller state like Kansas. In fact, I can't swear this is true. We haven't gone back and done all of our historical research, but just based on memory and word of mouth, I'm not sure we've ever had 3 up before. I can only think of one time we've had 2 up, and that was a little bit tricky at one time. I mean, you have them in a sequence, but not at once. And the time we had 2 up was a little tricky. It was actually the Carr brothers and the Sidney Gleason case that were consolidated. So it was 3 cases, but it was really 2 trials, and it was 2 issues arising from one common grant. So I mean, it was kind of an unusual procedural posture. This is really unusual. So we'll talk a little bit about that. And if I don't get too wound up and going on that stuff, which I could and run us out of time, I did serve in the Senate with Phil Journey for a while, and we can fill time, can't we, Your Honor? We can fill time. But assuming I don't run us out of time on that, I want to talk a little bit about a couple of other items we've got pending. So that's the game plan here over the next few minutes. You know, our office appears in the Kansas appellate courts a lot. It's a big part of what we do. We're right across the street from the Capitol one direction, from the courts the other direction. We represent the state directly or indirectly in every criminal appeal that goes up, and we represent the state or its agencies in a lot, though not all, not a majority, but a lot of the civil appeals that go up. And so we do a lot of appellate litigation in Kansas courts on behalf of the state and its employees and agencies and entities. And again, most of that you'll never know about unless you just happen to be involved in it for some reason. But occasionally cases go up that get a lot of attention because they are consequential. We've had 3 of those that have been in the news a good bit lately that I thought I might just talk a little bit about today. The first is the Hodes and Nauser case. The second is Gannon, the school finance case. I'm not sure there's much more to say on that one, but I'll say something and then we'll move on and wait. And then thirdly, I might say just a word about what I think was an interesting little case, and that's the one that was just resolved regarding the process for selecting the next judge on the State Court of Appeals. So that's the game plan on the state court side. Hodes and Nauser, everybody here would know it, or in common parlance, people think of that as the state right to abortion case. That's how it's been described. That's what it is. I mean, it was an appeal by providers in the Johnson County area. From a decision actually it was our appeal, but it was a case brought by providers in the Johnson County area challenging some of the statutory provisions the legislature has enacted in recent years. The appeal went through the Court of Appeals, wound up at the Supreme Court. And the question, as it's been described during the 2+ years we waited for the decision, was, is there an independent right to access to abortion services protected by the Kansas Constitution that is separate and apart from whatever the federal Constitution may provide? And the court decided, and of course the court said the answer was yes. That's been the headlines, and everybody's aware of that. And folks that are passionate on that subject matter on both sides, but particularly on the life side, are now engaged in conversation about what's possible next in a constitutional amendment and those sorts of things. I'm going to actually set that basket of issues aside, not because it's unimportant, but because everybody's familiar with it. Everybody knows Hodes and Nauser as the abortion rights case. But Hodes and Nauser, as it was decided by our court, is much, much broader than abortion rights. And forgive me here for a moment if I get down in the weeds, but I think it's worth it a little bit because we haven't talked about this much yet as a state, in part because everybody's so focused on the principal issue. I'm not sure we've gotten to the ancillary issues. What our court actually held in Hodes and Nauser is that Section 1 of the Kansas Constitution's Bill of Rights creates a judicially enforceable right. That's new. The prior case law had said that the rights protected by Section 1, it was either not clear that it was judicially enforceable, or there was some suggestion in some of the case law it was not judicially enforceable. This is me talking now as an analogy, not the court, but it had been in some ways compared more to the Declaration of Independence than to an enforceable constitutional right. And one of the things our court said in this decision is that that is not correct. That the rights guaranteed by Section 1 of the Kansas Bill of Rights are judicially enforceable rights, just like the right to free speech or the right to bear arms or the right to be free of unreasonable searches and seizures, that courts can enforce those rights. That's the first groundbreaking element of what our court told us in this decision. So that begs the question then, two questions. What's the standard that the court's going to use when deciding whether a government action, a law, a regulation, intrudes upon these judicially enforceable rights? How deferential would the court be in deciding whether or not a democratically enacted statute offends those rights and therefore can't stand, has to be struck down? And the court told us that the standard is strict scrutiny. Strict scrutiny. That is the highest standard that courts apply in reviewing a statute, or to put the same point a different way, it is the least deferential standard. So the decision on those 2 points is that courts in Kansas now may find rights in Section 1 and may enforce them by judicial order, and that in reviewing claims that a state statute violates those rights and therefore can't stand, courts are going to review those claims applying strict scrutiny. In other words, the state has a very heavy burden in trying to justify whatever statute it may be. So you can see that that's a pretty high bar. That's a substantial departure from where we were previously in Kansas constitutional law. And to the extent that applies in the subject matter of this case, which is state statutes regulating abortion, people who have focused on it are conversant in the issues. They get it. The third issue, however, the third point, is that the court didn't limit its holding to that subject matter. And put a different way, the natural question, the obvious question is, well, if a court can discover rights that are not plainly articulated, the word abortion doesn't appear in the state constitution, what other rights might be protected that aren't clearly articulated? If the court can discover them and can enforce them and is going to be inclined to strike down laws that intrude upon them in the event that they exist, then the obvious question is, well, what rights are those? How do we know what rights are going to be subject to this new review? And the answer is, I don't know. And I suspect nobody else does either, but it is a whole new frontier in Kansas constitutional litigation. Our court looked at the language of Section 1 of the Kansas Bill of Rights and compared it to the pertinent clause in the 14th Amendment to the U.S. Constitution. And the federal language is, I don't have it in front of me, but very close, is no state shall deny any person life, liberty, or property, I believe it is, without due process of law. That's the due process clause in the 14th Amendment. And prior to the Hodes decision, 2 months ago now, more or less, our court had generally said over all the previous years of Kansas history, even though the wording of the Kansas provision is not identical to that clause in the 14th Amendment and a similar clause regarding equal protection in the 14th Amendment, we're going to pretty much interpret them the same way. The court had never said literally they are exactly the same, but the court had largely said, if you're okay under due process federally, you're okay under equal protection federally, you're probably going to be fine under the Section 1 and vice versa. So they were more or less the same. The court very expressly explained in this decision that is not the case. That the language of Section 1 is materially, in the court's view, materially different from the language in the 14th Amendment, and it therefore protects something different. The key language in Section 1 is this. It says, all men are possessed of equal and inalienable natural rights, among which are life, liberty, and the pursuit of happiness. That's what our Constitution's language says. And the court pointed out that it differs in at least two material ways from the language in the 14th Amendment of the U.S. Constitution. Number one, the U.S. Constitution's language talks about process. The Due Process Clause, by definition, talks about process. And for most of us, especially on the more conservative end of the legal thinking spectrum, process means process. It means procedure. We're very critical as a philosophical matter of this doctrine of this body of law that people refer to as substantive due process, which sort of seems like an oxymoron on its face, but that's federal case law. It's existed for a long time, and that's what the federal courts have generally used when they find substantive rights in the Constitution that aren't clearly or plainly articulated there, but nonetheless are defensible. Our court pointed out, to the extent we compare Section 1 with the 14th Amendment, Section 1 must be broader in what it protects because it's not constrained by the term process. The concept that it applies to process does not exist in the state constitution, and so if federal courts can take the process phrasing out of federal law, find substantive rights, well then we must be able to do at least that much at the state level, is the court's reasoning. And point number two, there is nothing in the 14th Amendment of the U.S. Constitution or anywhere else in the language of the U.S. Constitution for that matter that expressly refers to natural rights. That phrase isn't there in federal constitutional law, but it is there in Section 1. All men are possessed of equal and inalienable natural rights. So our court put those two together and reasoned that because our language, our Constitution's language, is not constrained to merely process, and because it affirmatively protects some body of natural rights, it must protect more than what's protected by the 14th Amendment, or at least it can protect more than what's protected by the 14th Amendment, or at least it provides an independent protection, depending on how it's applied. And nowhere in that discussion does the word abortion appear. So we can only now ask ourselves, where does this sort of new body of Kansas constitutional law lead us? How are we going to discover what these new natural rights are that are independently protectable, subject to strict scrutiny by Kansas courts? And the answer is, I don't know. And to a certain extent, I don't want to simplify Justice Biles' point, but he concurred. He agreed in the outcome, but he concurred and essentially made the point he didn't know either. He thinks that the majority opinion sort of throws open the door to a whole lot of testing of the boundaries because there's not really a guiding principle. I will give you a concrete example of the types of things we're going to see. We're only, less than 2 months into the Hodes and Nauser decision. We have already seen on the state's behalf new motions filed in all 5 of the pending post-conviction Kansas death penalty cases that are on appeal. That includes Mr. Flack out of Franklin County, Mr. Thurber out of Cowley County, both of the Carr cases, obviously out of Sedgwick County, and Mr. Cross out of Johnson County. Those are the only death penalty cases where you have a person convicted, they're still on direct appeal as opposed to later appellate processes, and they're currently sitting in Kansas courts. So in every case immediately available to defense counsel has made the argument, understandably, that Hodes and Nauser now recognizes that there are newly discovered, inalienable, judicially enforceable natural rights. Section 1 actually expressly talks about the inalienable natural right to life. Therefore, they argue, the death penalty must be categorically unconstitutional in Kansas. It violates Section 1 of the Kansas Bill of Rights, they argue, for the state to execute somebody because you have this independent, natural right to live. The irony of the subject matter of the case that made that decision juxtaposed against a death penalty case is, a discussion for another day in a different place. But that's where we are, and that's not abstract. We are now going to litigate those issues in all 5 of those cases, and I suspect every other death penalty case until it gets resolved. And that's just what's shown up in the first, less than 2 months. So we'll see how things go. My only point in telling you all of that is, as the appellate defender wrote in one of their motions, Hodes and Nauser, and I quote them, changed the landscape of Kansas constitutional law. And I think that's a true statement. And I think it goes well beyond the subject matter at hand, and we'll see where it leads us going forward. Well, heck, that was only item number 1. I'm clearly not going to get to the good stuff at the end. So let me go to number 2, the second Kansas Supreme Court case. That's Gannon School of Finance. What else is there to say? This is the 7th time we've had this appeal up in front of the court, and I'm really hoping 7's a lucky number in this context. We're trying, and the argument went as well as could be expected. We will see what the court does. I presume before the end of June. I have no insight on when, but that's when their stay of their current order releases, and so I assume we'll have an answer before that. I'll just leave it at that. We'll see what the court does. You all know the issues on that. And item number 3 that's come out of the state high court recently, this is the decision on how to select the next Court of Appeals judge. I think that's all back on track now and back in the Senate's hands to decide whether or not Sarah Warner, who's the currently pending appointee, is going to be confirmed or not. I presume from public comments that they intend to vote, Senate intends to vote when they come back on sine die on the 29th. That's for the Senate to worry about. Our worry in all of this was that there was a sufficient dispute between the governor and Senate leadership that was plausible. I mean, it's not like one side was clearly wrong. I have my thoughts on who had the better argument, but that's immaterial. It's not like one side was clearly wrong on how the statute was supposed to be read. And our worry from the AG's office standpoint was that given that uncertainty, we wanted some certainty before the next judge gets seated, because otherwise what we feared was going to happen was that the next judge would get seated, and in every case that he or she sits on, the litigant who loses is going to argue, I get another bite at the apple through an argument that this judge is not properly seated. There is case law where that's happened in the federal system. And I'll admit a few times this all developed so rapidly, and there were a few times I thought, man, am I just worried about nothing? Until we showed up for the argument on this case at the Kansas Supreme Court, and the back row was full of all the appellate defenders with their notebooks out. I mean, they were thinking of it too. So I felt better after that. Anyway, we're back on track, and hopefully we'll get a Court of Appeals judge at some point who is indisputable. So that's a lot been happening at the Kansas Supreme Court. Let me say a little bit about our 3 pending cases at the U.S. Supreme Court. We actually have some more where they're multi-state cases, and we're part of a group. I'm going to set them aside for a moment and just talk about the 3 that are uniquely Kansas cases. We didn't have any granted at the start of this year. We thought, man, maybe we'll get 1, and then we got 1, and then we got 2, and then we got 3. So we're going to argue 2 in October and 1 in November of this fall, so the schedule's going to fill up. The first one, they're all interesting cases, but the first one I think is particularly interesting. It's a case out of Johnson County. It's a consolidation of 3 different state criminal prosecutions. The prevailing caption is Kansas versus Garcia. They're all similar cases where you had an individual who tried to go get a job and did not have a social security number. The record doesn't tell us why, but you can probably speculate why they didn't have a social security number. And you have to have a social security number to fill out your I-9 form, which you have to fill out in order to be gainfully employed. And so each of these 3 individuals went out into the black market essentially and purchased social security numbers, which did belong to somebody else. So you now have identity theft and you have a real victim, 3 real victims. And they filled out their I-9 and they got their jobs, and then they made money, and then they were trying, I presume, to do the right thing and pay taxes on their money. And so they had to fill out state and federal tax withholding forms, the W-4 and the K-4 as well. That's where they got into trouble, because you also have to have a social security number to fill out your tax forms. And so they put down the social security number that they had bought that was somebody else's. And they eventually each were caught, prosecuted, convicted, and the conviction upheld on appeal through the Kansas Court of Appeals for violating the Kansas identity theft statute and some related statutes, making false information, that sort of thing. Cases then get consolidated and go to the Kansas Supreme Court. Actually, they may not have been. They all go to the Kansas Supreme Court at once. And our court reversed the convictions. And the reasoning was the majority on the court held that there's a provision in the 1986 federal immigration statute that relates to how information on the Form I-9 can be used. And our court held that that provision preempts state law as to the use of any information contained in or appended to the Form I-9. That's the language of the statute, but we think what that means is you can't take the I-9, if you're the state, and enter it into evidence and say, see, look, they lied, they used a false social security number. We didn't do that. We don't think that means if they tell a lie on the I-9 and then tell the same lie again on a different document, that they're somehow immunized from the lie they told on the different document. That's what we think the law is, that you can prosecute them for this lie on the tax forms. We just can't, as a state, prosecute them for the lie on the federal employment form. But that's not what our court thought. Our court thought that both of those are preempted by federal law. I'm optimistic that the U.S. Supreme Court agreed to hear the case in order to reverse. Obviously, I don't know that to be the case, but I'm hopeful, because if not, eventually the stay will be lifted on our current court decision, and it's going to be chaotic, to say the least, in terms of our ability as a state, us local doesn't matter, to prosecute really any of the whole range of fraud crimes. Because at least by the reasoning of that decision, I mean, maybe the court would rein it in when you look at some of the really extreme results, but by the reasoning, it's not just a social security number that is information contained in or appended to the I-9. It's also your name, your date of birth. You also have to attach certain proof. So you have a copy of your state driver's license, or of your voter identification card, or of your university identification card. I mean, really, we can't prosecute anybody for lying on any of those state-generated instruments? So we're optimistic, but we'll see how things go. That case is up first. The second one's up is one of the death penalty cases out of Kansas, though not one of the 5 I just mentioned. It's not one of the 5 that was affected by HODIs yet, because it's not sitting in front of a Kansas court. It's sitting in front of the U.S. Supreme Court. That's Mr. Kaler's case out of Osage County. The issue there is that in the late 1990s, for reasons we're still researching, the Kansas legislature decided to abolish the insanity defense as a freestanding, independent affirmative defense and replace it with our current mental disease or defect provision, which we believe is merely channeling the ability of a defendant to argue that I can't be held criminally liable, but the defense believes has narrowed, impermissibly narrowed in their view, the ability of a defendant to make those arguments. It's an interesting case. I don't know how it ends up. Kansas is one of only, I think it's 4 or 5 states that have done that. So we don't have a lot of company in terms of others' experience that we can look at. And then the final case we have up, it's an important case, and I don't mean to belittle it, but it's kind of a fun little case because it's not something really heavy like employment law or immigration law or the death penalty. It's a traffic case. And not to pick on Phil Journey again, but this will get Phil's juices going. It's a traffic case, right? But it's kind of an interesting case, and it was tried in state court on stipulated facts, so it is a very clean case because, all the stuff that happens in the real world that you fight about that makes these cases hard to present a square constitutional issue, they always get mired down in facts. Not so here. This one arises out of Lawrence. It's a fellow who was driving down 23rd Street at about 7-something in the morning. An officer pulled up behind him, a sheriff's deputy. They were at a stoplight. The deputy ran his tag just, routinely because you can run a tag if you've got the ability sitting on the street. And the tag comes back and says that the owner of that pickup truck is Mr. Glover, and Mr. Glover's license is suspended. Therefore, the deputy deduced that Mr. Glover should not be driving his truck, and he stopped the guy. And Mr. Glover was driving the truck, and he was charged with driving while suspended, and he was convicted, and he appealed, and it was affirmed, and he was appealed, and it was reversed on Fourth Amendment grounds. And the issue is, when the Fourth Amendment says that we're all free of unreasonable searches and seizures, is it for that purpose reasonable to stop a vehicle when all you know is that the owner of the vehicle is not supposed to be driving, but you don't have any more information, such as, is the driver actually the owner of the vehicle currently? It's an interesting question. In this case, the United States is joining in with us. It'll be us and the Trump administration saying that's enough, and it'll be folks on the other side saying no, it's not. We'll see. I mean, I don't mean to make light of it. It is an important Fourth Amendment issue, but it's also the stakes in this particular case are low enough. Your blood pressure doesn't go up, but it has significant long-term potential impacts. I mean, for example, the whole automated license plate reader program, which may not have any idea who's driving my car, but they're going to know it's my car if they read my license plate. How is that impacted by whatever the court tells us? So some interesting issues on their way up. I think I've probably just about run us to ground here. I've got plenty more I'd love to talk about, but I want to be sure I finish before you do. So let me just do kind of a quick summary on everything else. We are, even though we have a friendly U.S. administration now who largely sees the world on these issues the way we do, we still have some holdover litigation from the Obama years, and we haven't given up on it. It's just not in the papers as much anymore because the Trump administration is not out there sort of trying to push the envelope. But our goal is to finish this stuff off and win, so we put a stake in its heart in case things don't go so well in a future presidential election. So we are still in court challenging the constitutionality of Obamacare, the Affordable Care Act, the ACA, whatever you want to call it. We actually have won the first round of that in federal district court in Fort Worth. Judge O'Connor's our judge on that. We're now on appeal to the Fifth Circuit in New Orleans. The good news is the United States has flipped sides on that. So it's now us and the federal government on one side and a little group of states led by California on the other side. We're hoping things go well as it goes up. We have a second Obamacare case that's gotten almost no attention, but the legislators' ears may perk up on this. We challenged one of the taxes in the ACA specifically. And we've won in the district court level. We're now the appeals headed to New Orleans as well. Bottom line is we've got a judgment right now, or we've got an order that's going to become a judgment right now that says that this health insurance provider fee that was one of the many taxes and fees in Obamacare was illegally collected from states. And if that's true, and if we ultimately win, it's about $60 million coming back to Kansas for our share that we paid unlawfully. So we're hoping that holds up on appeal. And by the way, the federal administration is still defending opposite us on that one. We keep pointing out to them, how can you argue over here the entire statute is unconstitutional and has to fall, but over here you're still defending this tax provision? Come on in, the water's fine, we'd love to have you. They haven't flipped over on that one yet. We're working on it. We're also still working on trying to get to final judgment to permanently block the waters of the U.S. rule. I think that's going to become moot soon because there's a new, EPA's promulgated a new rule to replace the old one, and the new one is much, much better. But we're not going to quit until that's done. As long as the old one's out there, we don't want it to arise from the dead. And finally, on kind of the federal front, there is a case that's going to be decided by the U.S. Supremes before the end of June. It was argued several weeks ago. And this is the citizenship census question. I think it's an interesting case. I don't think it's a very difficult one, but apparently others do. The issue is whether or not the United States may ask on the census form, are you a citizen of the United States? I think the answer is yes. And I'm not sure why it requires a whole lot of legal analysis, but it does. And so far, a number of lower court judges have disagreed, and we've had a U.S. Supreme Court argument on it. So I'm hopeful that will come back with what we view as the correct answer here in fairly short order. With that, thank you for letting me be here. And I'd be glad to either sit down, talk about something else, or
we'll ask you a few questions.
Take a few questions. That's a great suggestion. All right.
You raise your hand. We'll come around with the mic so your question can be heard. And we'll start up here.
Thank you, Derek, for coming to the Pachyderm. Really appreciate you being here and spending your time with us. My question is about sanctuary cities. And if I have my way, Wichita is going to become a sanctuary city for the unborn. And I want to know if a federal court and if state law enforcement upholds sanctuary city laws for things like immigration or drug use, wouldn't they also have to uphold sanctuary city legislation for the unborn?
Right. So, it's interesting because that's another one of those subject matter areas where, in my view at least, once you start sort of moving off what I would argue is a fairly principled interpretation of the law, and you create an exception, then you invite everybody else to want an exception as well. And so, this whole sanctuary city concept, which means different things to different people, there's not really sort of a definition, at least we haven't been able to find it. And I've looked, because one of the first things the Trump administration did, you may recall, this was the whole Chicago issue where they were upset with Rahm Emanuel, the sanctuary city. So they said no federal burn jag grant money to states unless you guarantee that none of the money goes to a sanctuary jurisdiction, which, sounded good until you read the fine print and discovered that the way the feds were enforcing that was to require the state attorney general to certify under penalty of perjury that none of the state's burn jag money would go to a sanctuary jurisdiction, but they wouldn't give us a definition of what is a sanctuary jurisdiction. So, I looked at that thing, I'm like, that whole federal perjury crime thing, my name, I think we're going to get a definition before I sign this thing. We actually skipped a year on Kansas burn jag money. We caught it up later. We didn't lose net, but we missed a year of timing, which I felt bad about, but the law enforcement guys understood. I wasn't going to perjure myself, and I didn't know the answer. There's no way to know the answer because we didn't have a definition. Sanctuary cities mean different things to different folks, but to the extent the general concept is a local jurisdiction decides they are not going to comply with federal law, whether it's in the immigration context or whether, there are a number of jurisdictions around the country now where I think sheriffs and some locals have said we're going to be a Second Amendment sanctuary jurisdiction, and if it comes to that, we're not going to comply with federal regulations, certain federal regulations related to firearms or maybe other subject matter like you talk about. Each of those has their own dynamics. My own sort of 30,000 foot view is we shouldn't have gone down this road of just saying locals can opt out of federal law unless you're going to challenge the federal law and try to get it declared invalid. That's perfectly legit, and we do that a lot. But you kind of got to have the horse before the cart, in my general view. Having said that, barn doors open, and I'm sure there are going to be folks take that invitation. So.
Next question.
Yep.
Thank you, Mr.
Hey, Blake.
Attorney General,
Yeah.
for being here. So I'm not sure why us legislators even go to peak at this point, because they're doing it for us, Supreme Court in that case, but that's not, you don't have to explore that one. But my question for you, since we were talking about citizenship, is where is our, when you register to vote, as far as proving that you're a citizen, where is that at currently in the process?
Right, so this is the issue, the statute that passed almost unanimously, overwhelmingly bipartisan. Senator Kelly voted for it, I believe, but that's neither here nor there. Back in 2013 or whatever year that was, that says, among other things, that you've got to prove your citizenship at the time you register. DPOC, Documentary Proof of Citizenship Law. Secretary Kobach was leading the defense of that. Of course, it was challenged by a number of folks, including the ACLU in court, and Chris was the advocate for it, and he wanted to lead the defense, and that was fine. He did that. Obviously, he's not in office anymore, and so Secretary Schwab and I visited about it about the time he was taking office. He wants it defended, but he had no interest in being the lawyer defending it because he's not a lawyer. So he handed it to us to finish the defense. So we have inherited that case. We are currently on appeal in the 10th Circuit Court of Appeals. You'll recall the state pretty much lost in the district court in Kansas City. We've appealed. There are sort of two general baskets of issues in that case, and without getting too far down in the weeds, one is whether part of our law violates part of the U.S. Constitution, and the other is whether part of our law violates a federal statute, but not the Constitution, the motor voter law. We're appealing both of those. We lost on both of those below. We're appealing both of them. We've fully briefed and argued the case. That argument was in Utah maybe 6 weeks ago. I've lost track of time. And we're waiting for the court to give us a decision. Once we get that decision, we'll see where we are, whether we think we have a good basis, whether we prevail. And if we don't prevail, then whether we have a good basis for further appeal or we don't. The difficult balance on this is, this is those of you that follow it, it's a federal civil rights lawsuit. It's a 1983 case. And so the losing part, if the state ultimately loses, we will not only pay our own expenses for having litigated it, we will pay the plaintiff's expenses for having litigated it. That's federal law. That happens a lot. Not just to the state, but that's not an uncommon mechanism, but it's a lot of money. And so, you always have to be careful in these. On the one hand, I think every law deserves a full defense, and I intend to give this one a full defense. On the other hand, you don't want to spend potentially a lot of money for an appeal that you have no chance of winning what have you accomplished? So I'm not trying to forecast where we're going. I'm just telling you those are the types of issues we're going to have to balance when we see what the circuit does. They're not. Well, I don't think the circuit judge is going to watch this, so I won't be, impeding their deliberations. I think that we've got a steep hill to climb on the statutory preemption issue, and the reason I think that's true is the case had already been to this case itself had already been to the circuit once previously, and the circuit panel already addressed the statutory issue, and Kansas did not win. So we not only have to overcome the issue on its substance, we have to overcome the law of the case concept that, hey, we already decided that, thank you very much. That's a steep hill to climb, and we're trying. On the constitutional issue, it's a little different. It does look like our district court was the first one in the country that we've been able to find that entered the broad holding that the 14th Amendment bars the state from doing what we've done. We think that's incorrect. And so I'm a little bit more optimistic that because it's a blank slate on appeal, we might have, our odds might be improved on that one, but who knows? It could be wrong on both.
Next question here.
Yeah, I think it's kind of obvious the judiciary is exceeding her authority by the court cases you're bringing in. But that's the reason why it's so important whether they're a conservative or whether they're a liberal judge is because of that excess authority. The question is there any way to get the judges back to where they have to consider the original intent of the Constitution makers or the lawmakers rather than coming up with their own definition?
Yeah, that's a question that I think the country has been debating since about the time of the Federalist Papers. I mean, really, that's, it's not a new conflict. I do think we may live in a time when it is a more troublesome concern because of the volume of involvement of the judicial branch in what have historically been policy decisions. And all I can tell you is what I think, which, others may or may not agree with, but I really think the only fix that has, a likelihood over time of sort of moving us in that direction, at least in the Kansas context, is to move to a modified form of selection for appellate judges. I'm a fan, I'm a fan of the federal system. I mean, as ugly as it is to watch some of these confirmation hearings and we all wring our hands and say, my gosh, that's terrible. Bottom line is, at the end of the day, it produces a federal judiciary that, it's the envy of the world. I mean, these are independent, well-respected actors, and it's a self-correcting system to the extent that, you get lower court judges that see things differently, you get greater homogeneity as you move up the appellate ladder and eventually to the Supreme Court. And ultimately, the Supreme Court does reflect the overall views of the public over time. We may not like it, but that's a reality. It moves to the left or to the right. The old expression is it follows the election returns, and there's some truth in that, not in a narrow sense, but in a broad sense. So I don't have a better system than that. That is not the system we have in Kansas. We have a nominating commission system, and I've been critical of that system since 2005, and I still am. I'm going to sort of, to the extent, folks ask me what I think today, I tell them, we tried doing nothing, leaving the system alone. There's discontent with that, at least in some factions. We tried dramatic change, constitutional change that would go strictly to a federal system, and we haven't gotten it accomplished, and I'm not seeing that likely to happen in short order. So, what we proposed in 2005, and I think I'll pick on Phil again for the third time, my recollection is he was part of this when we served together in the Senate, leave the nominating commission in place so that people who want to argue it has value, it's still there. Leave the governor's selection in place, but add a third step at the back end of the process, which is confirmation by the Kansas Senate, so that at least you have democratically elected. And by the way, you don't have to look any further than the recent Court of Appeals troubles to reach the conclusion, I think, that works. I mean, the reality is, if there hadn't been Senate confirmation, Judge Jack would be on the Kansas Court of Appeals, because the governor picked him after her ad hoc nominating commission selected him, and then she changed her mind 3 days later. There is no change in your mind when you're the final word. So I think that's proof that Senate confirmation works. I think it's a good thing, even though there were details that need to be worked out. So it's my own view. Others would differ. So.
Next question here.
Thank you for
Dave.
being here. Always a pleasure to hear you and to work with you, Attorney General Schmidt.
Likewise, thank you.
So I've just received notification that the governor has yet again vetoed the tax bill that was sitting on her desk. Thought that might be interesting. But that leads to maybe a little bit of a bigger question, and that is, who do you work for? And I ask that question because we talk about fighting against the ACA and things like that. Do you work for the citizens of this state, or do you work for the governor?
Right. The answer is I work for the citizens, but sometimes the governor is my client. And as a lawyer, I have obligations to a client. And so those can be in tension. Kansas, not unlike many states, but very much unlike the federal government. Our framers in this state decided to divide the executive authority into multiple independently elected components. At the federal level, the only elected official in the executive branch is the president, or the president and the vice president who run as a ticket. That's it. We don't elect the U.S. Attorney General. We don't elect the Secretary of State. All power flows from the people through the Constitution to the executive, through the president, and ultimately into those executive branch actors. That is not true in Kansas. In Kansas, we of course all elect a governor, lieutenant governor as a ticket, and the Constitution says the governor is the supreme executive authority, which tells us sort of the pecking order. But Kansans also wanted to be sure that we independently elect both a Secretary of State and an Attorney General, which we do. We also elect the Treasurer and Insurance Commissioner, but those aren't constitutional offices. You guys could change that if you wanted by statute, but you can't take my office away by statute. It would require a constitutional amendment. So I've always interpreted that as, I have an independent role to play in the executive branch of the state. And that was true with Governor Brownback, it was true with Governor Collier, and it's true with Governor Kelly. And I've said that to all three of them. The thing that makes my role particularly challenging, as opposed to, say, the Secretary of State's role, which is not to minimize, Scott's, but is I also, by definition, I'm a lawyer, and I provide legal services to the state. And lawyers, of course, are regulated not just as we all otherwise are as state employees, but also through the judicial branch as officers of the court. And we have obligations that are enforceable against our licenses. And some of those obligations include duties we have to our clients. And there are many times on individual cases where my client, or my office's client, is the governor, or is one of the governor's agencies, as opposed to the state itself. So it can be a little bit sticky. So far we haven't really had any direct disagreements on that. It might happen, and if it does, you just heard my view, so. All right.
Our next question's here, Fred.
Yes, I'm still concerned about voter fraud. I don't understand why we have paper ballots, that they've mailed to you. You don't know who actually votes that ballot. I don't see how that got started and why it can't be removed. Just like when in this past 2016 election, all of a sudden after the count was made, all of a sudden a week later other ballots turn up. And I think probably they were fraud. They were made to make sure that they would win and reverse the actual winner. What can we do about this? Why isn't this being corrected? Why don't we have fair, honest elections?
Good question.
Yeah. Well, I think I'd sort of answer that in sort of two tiers. Number one, not to state the obvious, but we're the state's legal team at the AG's office. We're not the state's chief election officer. And so to the extent, your question is, how do ballots get lost? Why are they not handled the way you might prefer, whatever that is? I think those are probably questions better addressed to Secretary Schwab, because that's what his office does. Second tier, to the extent your question is, look, Derek, you got a case here where clearly you've got a fraudulent act. Somebody pretended to be someone they're not, or whatever it may be, and they voted under false pretenses. It's a violation of a criminal statute. What do you do about that? The answer to that is, obviously, as in any criminal case, if there's evidence and it's sufficient evidence and it's admissible evidence, they ought to be prosecuted. It's a crime, just like killing somebody or stealing something. Election fraud, actually several crimes that sort of fit under that banner, but it's a crime. We're coming off a period in state history where that was such a hot topic of debate. Do this on why it was a hot topic, but it doesn't matter. It was a hot topic. And sometimes when issues become really hot political topics, it's hard to kind of calm them down and say, let's just focus on this matter in front of us. Is this a crime we've got evidence to prosecute, or isn't it? One of the things that Secretary Schwab and Scott and I have been working on, he doesn't want to continue his office directly continue prosecuting criminal voter fraud cases because he's not a lawyer. He doesn't feel comfortable overseeing the folks that would make those decisions. The law currently gives authority to bring those cases to 3 different entities, to the Secretary of State, to the Attorney General, or to the local prosecuting attorney. And so Scott and I have been talking about how we, proceed on that. And I don't think I'm speaking out of turn here. I mean, I don't want to speak for him, but I think it's fair to say, we have an understanding between us. To the extent the Secretary of State's office discovers potentially prosecutable fraud, he's going to walk upstairs and we're going to talk about it case by case, and we'll figure out, is it something we ought to see if we can bring? Is it something we ought to call the local district attorney or county attorney, depending on the jurisdiction, levels of interests, and priorities and all that? So we're trying to make sure those don't fall through the cracks going forward just because the state's kind of in a time of transition on who handles them. It's the best answer I've got for you. We've prosecuted, 2 or 3, not a lot, but 2 or 3 cases of election fraud, not just voter fraud, but election frauds our office has since I've been in office. All the attention was on the Secretary of State's prosecutions. That got lots of attention, which is fine. There's been a number of local prosecutions that got attention locally, but they, not so much statewide. We've done a small number, and we would continue doing those if a case landed on our desk that was provable.
Okay, thank
You bet.
you. Mr. Attorney General.
Hey. Bet you're thrilled the tax bill got vetoed. Yeah, Carl, is that right? Yeah, sure.
That's not my question, although it does kind of maybe segue into it indirectly. As a big critic of our state Supreme Court, I believe they've been in gross violation of the federal Constitution's Article 4, Section 4 provision guaranteeing each state a Republican form of government. And I think we've drifted into a judicial oligarchy. Having set that as a foundation, you may comment on that or as you wish or not, but as a demonstration of this, both the abortion and the Gannon-Montoya cases have been stretched out and have been delayed. Those decisions should have been reached last year. It should have occurred before the election. They should have been part of the campaign between Kelly and Kobach, in my opinion. Do you have any evidence in terms of the delays that are occurring in rendering judgments by our Supreme Court on how we compare with other states in terms of, I believe, justice delayed is justice denied, and we're seeing this egregiously on the part of our what I call the Black Robe Legislature, the 7 members of the Kansas Supreme Court.
Well, on the timing issue, I mean, there has been criticism of our court for what some view as the slow handling of a number of cases. I'm not sure Gannon quite fits that. I don't mean to quarrel with you, but in Gannon, they did make the decision before the last legislative session, and it was debated during the gubernatorial campaign. Then the legislature responded. So it may not quite meet that model. Hodes and Nausers different. As I suggested earlier, the time between when we argued that case at oral argument and when the court decided it was more than 2 years. I think it was about 25 months. And that is unusually long and is somewhat frustrating. So I don't have that data in my head. It exists. I've seen it in terms of average, time from argument to disposition. I think it is, accurate to say that there are, lines of criticism among the bar of sort of the pace at which appellate cases sometimes get decided, and we would all prefer that they be decided expeditiously.
Well,
So.
Mr. Derek Schmidt,
All right, thanks guys very much. Thank you.
Appreciate it.